Hi, I'm Lana.
Hi, I'm Sherry, and this is Real Estate Tips with SNL.
Thanks for joining us today. We are going to be talking about navigating the legal side with real estate. And today we have Attorney Craig Reynolds from Reynolds Law Office talking with us.
Some information that I'd like to share about Craig so I can toot your horn for you. You graduated from law school in 1981, and you opened your own law practice in Lancaster in 1984. Lana and I were talking about this being about the time we graduated high school. So,
Yay.
Yay.
Those dates do establish how old I am.
Yes, us as well. Now, since then, your firm has grown, and you now operate from 3 locations. You've got your original place in Lancaster. You're also in Westford and in Fitchburg. You are, I feel, a reputable real estate attorney within our local real estate board. You've also been recognized as Business Partner of the Year 2 times. I'm so grateful that you took time out of your busy schedule, not only today, but for the many times that you actually help out us as realtors with continuing education classes. I feel like you are a wealth of knowledge, and we are grateful to have you here. And a little personal thing, you're a husband, a father, and a grandfather. So thank you so much for coming today.
You're welcome. Very, very excited to be doing my first ever podcast.
Yay!
Wow,
Yay.
honored. We are honored.
I'm sure it'll be the first of many,
Yes.
But we get to be the ones that brought you in.
There you go.
Right. So, what should we talk about today? I thought we would start talking about, we know Massachusetts is a buyer beware state. But what does that mean to our audience? What does that mean?
So basically, and I'm always surprised by this, given the how consumer-friendly Massachusetts is. But when it comes to real estate, a buyer beware state, what's known, the technical term is caveat emptor, one of the few Latin terms I learned somewhere along the way.
Latin's required with a law degree.
Yeah.
Apparently so. But basically, meaning that it's all the burden is on the buyers to do their due diligence when they're buying a property. There is very little that a seller is obligated to disclose about a property as far as defects. The burden is on the buyer to find those defects, whether it's through a home inspection, whether it's through questions to the seller, asking the sellers to provide a seller's information sheet, disclosing information about their property. Sellers are under no obligation to provide any information. When a buyer asks a question, the seller can either answer and do so truthfully, of course, or just refuse to do so. And we see in different market conditions kind of changes sellers' willingness to provide that information. Right now, in a very strong seller's market where we've got multiple offers for every property, the norm is for sellers not to fill out that information sheet. In doing so, they potentially create some liability on themselves because they have to be, once they start answering questions, they have to be totally straightforward and give complete answers. And there's always the possibility that they've forgotten something or they give a misleading answer, which potentially leads to liability later on. So any seller who asks an attorney, should I fill out a seller's information sheet? Attorneys are often going to say there's just no upside for you, at least in this market, where there's multiple offers on it.
So you were mentioning, and don't want to stop your train of thought here, you were mentioning just there, you said there are some things. Is there anything that is required from a seller to make sure it's said?
So, lead paint is really the only thing that sellers are under an obligation to divulge information they have about the property. State law requires sellers to do some due diligence on smoke detectors, carbon monoxide alarms. They have to have those inspected by the fire department and certify that they're up to code. They have to.
I'm sorry, I'm going to interrupt you on that. So that's state law. I thought that some lenders required that they are required to provide we call it a smoke certificate.
Well, so there is a state law that says in every sale transaction, I'd have to read the statute whether it says the seller has to. It probably doesn't. There shall be an inspection of the smoke detectors and carbon monoxide alarms.
Because I have seen it waived. Like an investor is planning to, make renovations to the house and is going to need a smoke detector certificate after the work is done.
Just because there's a state law that says you're supposed to do something doesn't mean people do it.
Okay, all right.
So the question is always going to be, what are the ramifications for ignoring the law?
Okay.
I exceeded the speed limit coming here today. I took a risk.
I did too.
Okay, so we have the lead paint, we have the smoke.
And septic systems. If there's a septic system, again, state law requires that there be an inspection of that septic system in most instances when there's a sale of the property. Mm-hmm. But as Sherry noted, in cash transactions, so I always say both on smoke detectors and on septic systems, there really aren't any smoke detector police out there or Title V police out there.
Right.
Well, there is a Board of Health on
There's
Title V.
There's a Board of Health.
But who's really checking up on that is if there's a lender in the transaction, they're not going to loan money on the transaction without appropriate certificates in hand.
True.
Okay.
So when you've got a cash transaction, an investor transaction, you can knowingly, waive those requirements. You can push the responsibility onto the buyer for smoke detectors, or Title V.
So as you're talking and where we are in this market, it sounds more and more that sellers can actually sell their home as is.
Absolutely.
So when there's language in there, whether it's in the disclosure on the listing itself, in the websites and whatnot, or if they're use it as a negotiation, when they say as is, what does that really mean? Through the whole transaction.
So it pushes all the responsibility onto the buyer. Figure out what it is you're buying. Do your due diligence. Know the product you're buying. Ask questions if you can get answers. But once you sign the contract, you're acknowledging that you've seen the property, you know what you're getting, and that's the condition of the property that you're agreeing to buy. Now, every contract's always going to have, or virtually every contract is going to have language in it that the condition of the property is expected to be in the same condition at closing as it was at the time of the offer.
Sure, right.
So as is, because I've had clients say, well, it's as is, so when the tree fell through the roof last week, I don't have to repair that.
That makes sense.
So there's a moment in time, there's a snapshot of the property when the offer is submitted that establishes what as is means. Seller's obligation only to deliver that the property in that condition.
Now, we do have buyers that are obviously doing a home inspection. Mm-hmm. They do a final walkthrough. I would say the final walkthrough, in some respects, it's good to do it a little bit before the closing in case there were repair issues that were agreed to that you want to make sure were completed. But in other cases, it might be best to do the final walkthrough just before going to the closing table in case that tree went through the roof overnight while you weren't there. I had actually shared with you, Lana, that, and I won't get into too much detail on it, but I did have a situation at the closing where the final walkthrough went well. And then after, when the buyer went to take occupancy, said that the refrigerator wasn't working. Now, they also admitted that during the final walkthrough, they didn't open the refrigerator. So they don't know if it was in the same condition. We were able to work everything out, but that could have been very complicated, if we didn't have two parties who are willing to work together to come up to a solution.
Well, in standard language in virtually every contract is going to be that once the deal closes, so once the deed is recorded, once the buyer owns the property, that is them recording the deed is their acknowledgement that they're satisfied with the condition of the property.
Right.
So in your situation there, if they come back the next day and say, oh, the refrigerator's not working, it's nice if a seller's cooperative and willing to do the right thing. But the legal answer is the seller was under no obligation to do anything.
So the right thing and the legal thing may not be the same thing.
Exactly.
And what about, I've had buyers come to me after the fact and say, okay, well, the hot water tank blew or something else happened. They always ask me, what's my recourse to a seller after that? And what is the recourse? Short
of the sellers having gone on the record representing, this hot water heater's in perfect condition, it's going to last another 10 years for you, which doesn't happen.
Right.
There's no recourse.
So at the point of recording, a buyer is now the owner and there is no going back to the seller for any recourse.
In general, yes. So, I mean, the caveat to that is if there's some sort of fraud on the seller's part. So if the seller is actively hiding things so that the buyer can't reasonably
Got it.
find it, then potentially the buyers would have some recourse. When those situations come up, I just always refer buyers to litigation attorneys. So, not my area of expertise, and litigation attorneys are just way more creative than I am in figuring out how to get around that as-is clause. So, to your question, does the as-is really mean something? Yes, it should.
Yep.
But there's going to be caveats. If the seller really has dirty hands,
Right.
A good litigation attorney is probably going to find a way to get around that.
Right. Yeah. And we love those phone calls, don't we, Lana?
Oh my gosh. No.
Yeah. I mean,
But to your point earlier about doing the doing the final walkthrough just moments before the closing.
Yeah.
I mean, I had a situation a few years ago. It was a winter closing, January, February. It was vacant property. The buyers, for some reason, did their walkthrough days before closing. We always start our closings with the buyer. Have you done your walkthrough? Did everything go okay? The response was, yeah, we were there a few days ago. Everything's good. And I'm a little nervous about that, but not my job to tell them. That's foolish of you. So we do the closing. This is back in the day before e-filing. So this was a few years ago. So I had to literally drive down to Worcester to record the deed. And on my drive down, got this panic call from the buyers, like, stop everything. We just went to the house. Pipes had frozen. The water was through the basement up to the main floor. So moral of the story is, do your walkthrough
just before.
Right before the closing.
Yeah, and you bring up a good point too. And I'm probably going to jump ahead a little bit, but you don't actually own the property until you're on record.
Correct.
So you leave the closing table. You've given them some money, and you think you own the house, but not yet. It still needs to record. You just gave an example where it didn't go on record because of this problem. I had one years ago where, sadly, we left the closing tables. I represented the seller on that sad deal. We left the closing table only to get a phone call that when the lender did their last minute credit pull, they found something, but our closing was before the lender's office had opened. It was early, so they stopped it, and it was something that prevented the buyer from moving forward. And I know, and I was supposed to get top producer that year. That was that one deal, that screwed me up. But I mean, and more so, my clients had moved out.
Yeah.
It was just horrible. I can tell you, honestly, I haven't had a horror story since that, but there are those occasions, and nothing's a done deal until it's a done deal. So, hopefully I didn't just scare everybody.
Well, I mean, particularly since COVID, lenders are just much more right up to the last minute making sure they're employed.
Yeah.
Because back in COVID era, we had people getting laid off
Right. So
the morning of closing.
Yes.
So it happens.
Yep. Into a different direction. We just talked about this briefly in our office, but I was hoping you could elaborate. And that's estate sales. We're going to take on a listing, and we've been contacted by a family because somebody has passed away and they need to sell the property. How do we prepare for something like that as listing real estate agents?
So first off, the first question is always going to be, when do we have what triggers an estate sale? Because obviously we got someone dead, but not all dead owners of real estate result in the need to go through any sort of a probate process.
Right.
So when you're talking about an estate sale, I'm reading that as we need to go through the probate process.
Right.
So just a quick background on that. So anytime someone dies, the legal question is, how do we determine who now owns their property or who's entitled to sell their property? Sometimes the form of ownership itself, so the wording in the deed, will answer that question for us. So if you've got Joe and Susie, husband and wife, owning a property, and on the deed it specifically says the whole title is tenants by the entirety, which is one of the forms of ownership under state law. One of the key features to tenants by the entirety is survivorship rights. So if Joe and Susie, tenants by the entirety, only for a married couple,
right.
And Joe has passed away, Susie automatically owns the property. We don't need to do anything relative to Joe having passed other than just to document that he did pass by recording a death certificate at the Registry of Deeds. Same thing where you've got multiple owners owning a property as joint tenants, another one of the forms of ownership. So the key feature there, survivorship rights. So you've got two or more people, no particular relationship between them. As joint tenants, one of them has died. The survivors of that group just automatically own the property. Again, nothing more than recording a death certificate. But when you don't have one of those two forms of ownership that just answer the question for us, or upon, if you've got the Joe and Susie situation, Joe has passed, Susie now owns it. Now Susie has passed.
Right.
So we don't have any automatic survivorship there. If you've got title in, Joe just in his name alone, or Joe and Susie as tenants in common, the third form of ownership, there's no survivorship there. So when there's no automatic survivorship, now we need to figure out through the legal process, through the probate process, who's the next owner of that property, who's entitled to sell that property.
Even if there's a will?
Which then
Dun, 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 dun.
Oops. Which then leads to the question: Joe's gonna be my dead guy? So
Poor Joe.
Did Joe have a will or not?
Right.
So with or without a will, we still have to go through the probate process.
Really? Okay.
So the probate process is determining who the heirs of the estate are, who the personal representative is, what authority they have, and such. But a will is just a piece of paper, that expresses Joe's intentions and such, but it has to be validated by the probate court. So it's only in the movies, but so the process is presenting all the paperwork to the probate court and saying Joe died with a will or Joe died without a will.
Which is the easier or the quickest way, with or without? Or does it matter?
With. Yep,
Okay.
exactly so.
So the wishes are known.
Yep, exactly so.
How long does it take?
So it depends. So,
Another long legal.
This may go down several roads that are longer than you really
That's okay. We got time.
There you go. So the initial process is for the court to determine whether the will that was presented was really Joe's will, or whether, like in the movies, Joe signed a will last night and left it all to me, kind of a thing.
Yeah.
Or if we say Joe had no will, well, maybe someone has a will out there.
Yeah.
So the initial process is did Joe have a will or not? Is this the
right.
the legitimate will? That can take up to a month or two, depending on the process, to totally validate that will. In the most common scenario, if Joe has a will, and if you just want to learn another fancy word for the day, that means he's testate.
Yeah.
If he dies without a will, he's intestate. Just so you can throw that around to your next party or whatever.
There you go.
It's not a medical term. It's
So if Joe did have a will, typically the most common provisions in a will are going to appoint, designate who he wants as his executor. We now call that personal representative, but everyone knows it as executor.
Yep.
Same concept, just different terminology now. If there is no will, the court's going to go through a process to appoint, one of the family members is going to step up and say, I want to be the personal representative. So you have to go through a process for that. So if he had a will, once the personal representative is appointed, that authorizes them to deal with all of the assets of the estate except real estate.
Real estate.
So throughout many areas of the law, real estate just has a special place, special rules for real estate. So once you're appointed as the personal representative, doesn't necessarily mean that you then have authority to sell the real estate. You then have to go get a license to sell, unless, and this is the most common scenario, in the will, there's a provision where Joe said, effectively, here's the way I want my personal representative to be. I trust them so inherently that I am giving them authority to sell my real estate.
Oh.
So that's what's known as a power sale clause.
Wow.
So once we have that clause in there, now the personal representative, once they're recognized as such, now has authority to sell the property.
So that's why at times, that's why at times I am told, don't forget to disclose we need a license to sell. Or like I have a lot of estate sales, or there's one that comes up and they say, nope, we don't need a license to sell. I'm like, we don't, but I have a personal rep, right? So that's why.
So if there's no will, automatically need a license to sell.
Correct.
If we have a will and there's a power sale clause, don't need a license to sell. But if there's no power sale clause, then we do need a license. But that's not the norm. And the good news, when there's a will, when there's a power sale clause, we can go the informal route, which is the short route to get the will recognized, and that can take a couple weeks.
Got it.
So we have a deal right now where I've got an elderly client who's my seller, but she's in very bad health. The son is extremely concerned that she may pass away before our closing date in a month.
Right.
And it's like,
Yeah.
all the personal stuff aside, how unfortunate that would be, et cetera. But it's
Right.
it would have really no impact on the real estate transaction. If she passes, we file probate. There's a will. There's a power of sale clause. A couple weeks later, we've got the personal representative can now sell the property.
Interesting.
So now that you've gone there,
Yep.
so obviously we all have expiration dates, and so perhaps our seller has already signed over, the deed and everything, and the day of the closing passes on. Are you still able to close?
So, like in advance?
Like it's the day of the closing or the day before.
But she already signed everything.
But yes, Joe already signed everything.
Yep.
And then Joe had the misfortune of passing away before you recorded the deed.
Bum, bum, bum. What happens?
So, to give a definitive answer on this, I'd want to go back and refresh my memory on the rules. But basically, it is not necessary that Joe was alive at the moment the deed's recorded, but it is necessary that Joe's still alive when the deed is delivered to the buyer.
Oh.
So you then get into a technical question as to when was the deed delivered.
Okay.
So if the buyers have already signed all of their paperwork, they've done everything that they need to, all that's left is filing at the Registry of Deeds. Potentially there's an argument there that the deed has been delivered. So Joe having passed away may not be a problem. Okay. In a situation like that, the closing attorney, who's the buyer's attorney, which is usually the closing attorney, is always going to check with the title insurance company just to make sure that they're okay with the fact pattern.
Okay. So
we did have a deal, not mine, but I'm aware of a local deal where the seller passed away at the closing table.
Oh my gosh.
Yep.
Oh, that's
devastating.
awful.
Oh my goodness.
I know.
guess
So
you've seen everything.
So if at some point we get onto the topic of what can go wrong with deals, well, there's an example.
Sellers are no longer allowed to attend the closing.
Well, it's true. That doesn't happen very often. Yeah.
No, I mean, it's funny because I feel like in our market, it was for a long time common for them to be on both sides of the table.
Yeah.
And, usually it's we're going to talk about the house. We're so excited, our family. And, on occasion, they shouldn't really be at the same table.
Yeah.
But I think more often than not, it's a very happy, chatty time for both sides. And then COVID happened.
Right.
But I also think that was unique to our area because I know I've sold, I'll say in Worcester, and oh no, the seller's never there at the closing. So now it's
customs
pretty
and
rare.
practices vary substantially, certainly from state to state, but county to county, sometimes town to town. That's just how things are done around here. Yeah.
Yeah, but I haven't had a buyer and seller at the same closing table in a while.
I'm sure you have a book that you could tell us, but what are some of the things that do happen or could happen that result in not fulfilling to the end?
So, the most common scenario that delays a closing are going to be title issues. And there's just a myriad of issues there.
Now you do your own title searches too. So
Correct.
you've got, which I love that your office does that. I don't think that's a common practice that I'm aware of.
No.
And so you have firsthand knowledge of title issues.
So
there's your segue.
Yes.
So again, the type of issues we run into that can delay a closing is just run the gambit right now. We've got a deal right now where, excuse me, I'll give you two right now stories. One, we just did the title a few days ago. We're supposed to be closing a week or so from now. But when the house was built, it's a relatively new house. The seller is the second owner of the property. When the subdivision was built, there were some wetlands, so the Conservation Commission got involved.
Oh, that's it.
We've all run into this. So the Conservation Commission, gives a permit, if you will, for the development, but with stipulations. You've got to do X, Y, and Z to protect the wetlands and such.
Yeah.
When the project is finished, the developer is supposed to go back to the Conservation Commission, get them to
sign off,
issue a certificate of compliance. Invariably, that doesn't happen. So why this was not flagged as an issue when the seller in the
Right.
transaction bought, that's an issue for them to take up with whoever their attorney was.
Yeah.
But so we found this open order conditions, called the Conservation Commission. Is this going to be an easy thing? This developer is a problem.
Oh,
there are
no.
there are still unbuilt lots. The whole deal is on hold because he's not complying. So we can't close until we get the Conservation Commission to sign off, at least on our house.
Well, what about title insurance?
Title insurance,
Doesn't the seller have title insurance for coverage?
that's between them and their title insurance
Yeah.
company. But sometimes title insurance companies will argue sometimes that an order of conditions is not technically a title issue.
Got it. Wow.
So that deal's on hold right now.
Okay.
We've got rate lock issues at Jeopardy,
Yes.
et cetera. Another deal, actually, I just got an email as I'm driving up here that the deal may be back on, but a deal from last summer. One of the things that we do is we send a surveyor out to the property to check boundaries, make sure the structures are within boundaries, comply with zoning setback and such. So the survey comes back showing there's a good-sized barn on the property, or not on the property, I guess I should say. A barn associated with our property that is totally on the neighbor's property,
no.
which is a problem. So I contact my client. I'm hoping that this is an old, dilapidated, I want to rip it down barn.
Yes.
No. The barn was just built in recent years and is one of the primary reasons my guy wants to buy this house.
Oh, no.
Time
What
to buy the
happened?
land that it's sitting on.
So we approached the poor seller. Again, we're having a tape survey, a plot plan.
Yeah.
The seller also had a tape survey done.
And it didn't show.
Didn't show because they were using one of those fly-by-night surveyors out there.
What?
The $110 surveyors that
I was
don't
gonna
even go to the
say,
property.
A tape survey and an actual
Just
Survey.
the level of accuracy differs.
Yeah.
So, an actual survey, when you see all
Yes.
the crews out there with the tripods and whatnot,
Yes.
so, they're measuring things down to, the fraction of an inch.
Right.
A tape survey going back in time, before you had any of the modern technology, they went out with a tape measure.
Yeah, they did.
And
They
they
just-
would find pins, markers, whatever, to determine where the corners are, and then they would triangulate off of that to determine where the boundary was, where the structures were, and whatnot. So we've been fortunate that we've always had really, really good surveyors over the years, and they say we're plus or minus a foot on our stuff.
So if Joe and Susie are paying cash,
Yep.
okay, Joe's still alive, okay, but Joe and Susie are paying cash, and the house is vacant,
Yep.
and they say we want to close in 1 week, but we want you to do a title search. Unrealistic, or it's possible,
We
but
can
it
do
depends
anything.
on
Not
the
for
property.
Craig.
Not for
He can do anything. You're talking to Craig Reynolds.
Oh, thanks, Lana. So we generally ask for 2 weeks. So there's three things we have to do to be ready for a closing. Usually, the title search, which we do that in house. We can control the title.
Yep.
We can bump someone else out of the way, but
Yeah.
we can't do that for every deal. Someone has to stay on track. We need to typically send a surveyor out to the property. They're asking for a week plus to get in queue because they're running all over the state.
Sure.
And we have to get the MLC,
Yep.
the municipal lien certificate from the tax collector to verify taxes and such.
Because it's a lien on the property, right?
They're the holdup. So
Especially if they're only in office 2.5 days a week.
yeah, exactly so. So
Okay.
I mean, some towns are better than others.
Right.
But state law says they have 10 days to generate it, and some
Okay.
will say it's only day number 9. I'm
right.
doing my nails right now. Tomorrow's day number 10.
All right. So Joe and Susie really need 2 weeks, ideally.
Yeah.
Okay.
2 weeks. 2 weeks is
Yeah.
what we asked for.
Okay.
Yeah.
The quickest deal we've ever done is we heard about the deal for the first time at 9:00 on a Friday, and we closed it that afternoon.
Oh my! With the
Wow.
title and everything.
Title and survey, no MLC, but we got copies of tax of
Told you he was a
paid
superhero.
receipts and such.
Yeah. Yeah. Look at that cape. Woof. Yeah.
And you want to do that
But-
all the time, don't you?
Anyone listening, I'm not putting that out there. That is the norm.
I don't want to work under that stress every day. Oh, yeah.
So you were going in the direction, Lana, of other things that could potentially
Yeah.
derail a transaction.
So sellers being ready to deliver. So title issues and
Yeah.
such, condition of the property.
Yeah.
So think September 11 in Leominster. There were some number of properties that were under contract to close that didn't close on time. The buyer has to be ready. So you gave the example of someone where at the closing table the lender found out that they weren't employed anymore.
Yeah,
that's extremely rare. Yeah. But financing issues are a common reason why closings get delayed. Not often, die from that. But it all comes down to buyers, the listing both agents, the buyer's agent as well as the listing agent, vetting that buyer, getting a really strong pre-qualification letter, dealing with lenders that that their pre-qualification letter means something. But going from a pre-qual to a commitment, y'all know, there's the lenders digging more deeply, and some lenders take more time than we'd like them to. And they find things that they weren't expecting. They're asking for more questions. Lenders are brutal.
And they have to be.
Yeah.
They have to be.
Yep.
So it's definitely not the early 2000s anymore. So,
Well, I'm just curious, what is some things that you wish you see for an improvement of either from the agents to help out or just having information sent to buyers from lenders maybe? What are some things that you see on the legal side that, would help more in the whole process of either sellers or buyers or anything like that? Anything that you can see?
I mean, the most important thing is getting buyers to a good lender. So, buyer agents need to do a better job. The pros do this.
Thank you.
The newer agents need to have more confidence to take better control of their transaction.
Yeah.
So the internet's out there. Obviously, there's buyers come in pre-approved with they watch the TV ad. So push the button and you've got a pre-approval and things like that.
ABC financing, we're your one-stop shop.
Yeah, exactly.
I think that's a really good point that you brought up because oftentimes people are hesitant to hear referrals or recommendations that we give because, their family is telling them one thing or another. But it really does come down to a team effort, right? Knowing the reputable lenders that are going to be able to get you to the closing table with the attorney that's going to handle that transaction, and then with us helping along the way as, guiding them as well. But I think there is a thing called a reputable lender or, it's not
a reputable attorney.
Yes, it's not just anybody out there because I think that's so important where I think consumers are a little bit leery when you start saying, well, here's a couple of names or here are some things that you need to think about because, mom and dad or Uncle Joe or somebody was telling them, no, you got to use my guy out in New York.
I've got a deal right now where a local agent who's very good to us refers a lot of business over to us and trusts us. Sent a referral over the other day, and then she had to follow up and say, "Oops, sorry, I was too quick referring you. My clients are using a family attorney who's not even a real estate attorney." And so my response was, "Well, good luck with that." So it all comes down to putting the team together. The most important decision in there is the lender because the lenders are going to make or break the deal. And they're going to hit their dates or not hit their dates.
Right.
And as a listing agent, vetting those pre-approvals in this day where we've got multiple offers, and you all know, but the best offer price is not necessarily the best deal. It's the package that buyer brings, starting with who their lender is, and who the closing attorney is that lender chooses, because the closing attorney, once the deal's in our lap, or whoever the closing attorney is, we kind of control the transaction.
You do.
We can make it smooth or a disaster.
Yep.
I have a question. This is two parts, and it's regarding out-of-state clients. So I seem to have gotten a few out-of-state sellers. I'm actually working with one right now. I will be setting you up on that as well. And, it's a situation where they're not going to be here. In fact, I think family's going to go over and pack up the house, and whether or not you'll ever see this person, I don't know. So It's not that uncommon, actually, for sellers that have properties to sell that they aren't here to sign for. How do you deal with that? What do we need to do on our end?
Doesn't really change anything on our end, but we all need to be very careful that we're actually dealing with the owner of the property.
Yes.
There's
we had that other one. I forgot about that. Yeah. Go ahead.
Well, there are creative criminals out there.
Yes.
And the one you're hearing a lot about now is, and this is more typical with vacant land.
right.
Because if they're selling a house, well, you can go to the house and meet them. And if it's
I personally know the person I'm going to be referring to.
Okay. But particularly in vacant land, you have to be really, really careful as to who you're dealing with. I had a realtor the other day contact me for potential seller rep, and vacant land, and the seller was in Canada. A lot of them profess to be in Canada, but so I did a little Google people search, and this person lives in the actual owner lives in South Carolina, and there was this old falling down cabin on the property. So I'm telling the realtor, number one, check these phone numbers down in South Carolina to see if you get someone different. Secondly, start talking about the history on this property and when he went as a kid out to the camp out there, and see if this guy can tell you stories, and then get everything notarized. So we're ultimately relying on just your sense of smell, if you will. Something that doesn't seem right here, but any documents that are going to be signed when you're never meeting with them are going to be signed remotely, are going to be signed by notary public. So we go so far as to vet who the notary public is, to make sure that they're a legit New York notary public or whatever.
Wow.
But if it's just other than the fraud component of it, just out of state sellers, not really an issue at all. Other than just we're dealing with them via email rather than in person.
Right.
We're needing them to find a local notary public to notarize the deed and other documents.
Power of attorney and things of that nature. What about a buyer? Can a buyer that is not in Massachusetts purchase land without being present?
So it's going to depend in part whether they're paying cash or getting financing. So if you get a cash buyer, we do that all the time, where buyers are not here, whether it's land, a house, or whatever.
I'm in Nicaragua, and I have $3 million cash, and I want you to help me.
She's trying to create a story here.
Yeah. No, so I do have one of those good stories.
Oh my.
So ultimately. So when you're dealing with a seller you've never met, the question is, are they legit? Are they impersonating?
Yeah.
When you're dealing with a buyer you've not met, ultimately I couldn't care less whether they are who they say they are. If their money shows up and it's good money,
exactly.
There you go.
Exactly.
We're looking for proof of funds, which is basically a statement from a bank, or their.
So we had this very situation a few years ago where we had a cash buyer. They had presented proof of funds. On a Canadian bank.
Here we go.
So sorry for all you Canadians out there. It's nothing personal. But I think the reason for that is we all think of Canada as just part of an extended part of the U.S. It's just familiar to us. So if we're getting someone from Ethiopia, we're like, this is odd.
Yeah, right.
But the Canada part and the Canada part explains why. Well, it's just taking a little longer for the funds to transfer and whatnot. So it just gives them a good story. So we get this proof of funds with just really even amounts in there. Like it was $2 million.
No one has just $2 million.
But so we don't know. So we're going through this transaction. The offer deposit bounces. But he's got a good story. We get to the PNS. He's having a hard time He just closed down one account, opened another account, and there's just this. Okay. There's always this good story. You're calling him, emailing him, whatever, and he's slow to respond. He said, "Oh, sorry, I was at a BMW driving event." Just all this good stuff.
Yeah.
So come to what we all surmised, and then we literally got to the day of closing. We have a closing package. Is he going to walk through the door? He never does. Who did walk through the door was the beautiful young woman that he was wooing, and he was buying this house for her. So he had just been playing her the whole time.
Oh no!
Oh gosh!
Oh, that's terrible.
So
That was
I know
Joe. It was Joe.
I know I've asked you this before, or your office anyways, but I just want I want the listeners to hear. So has anyone come into your office, a cash transaction, and just dropped a bucket of cash on it? And what do you do about that? I mean, because it has happened.
One,
Two.
No,
two.
Well, I got to tell you, a stack of cash is just way more impressive than a check that has that amount on it.
Of course. Right? But think about it.
So yes, and can we handle cash? Yes, but only up to $9,500 or whatever.
Yeah.
Because any transaction where we're depositing that, once you hit the 10,000, that triggers all sorts of reporting requirements and whatnot. No, we're just not going to go there. But we had a deal literally just last month where $200,000 property. They had a $5,000 deposit with the offer, so $195,000 due at closing. Buyer contacts me and says, so I'm getting the money from my uncle. And
he's a drug dealer. I'm sorry, I've been watching Breaking Bad.
Oh yeah.
But the uncle's legitimate.
Yeah.
And wanted to bring $195,000 in dollar bills. And
who does that?
Yeah. So I said, we're really not set up to accommodate that.
Just going to put that under my mattress. It's all good.
But I mean, at one time, it has to have happened in the past. Obviously,
Sure.
Has that happened when you as an attorney?
So yes. I mean, we've had people 195. I've never had someone offer that much, but more, 20, 30, 40,000. I'm saying I can't.
Right.
Because not that I can't, but I'm not willing to just go through whatever it's going to trigger at the bank when I deposit that.
I mean, we do provide instructions at closing. Bring a bank check.
Which we've changed our terminology.
Oh, okay.
Because bank check, cashier's check, same thing. But a lot of the younger generation don't have checks at all.
No, they don't.
And someone has told them that you have to set up a checking account for this transaction because people are going to be asking for checks. So they provide a check written from their bank. It's a bank check.
Ah, okay. Yeah. Again, we need to talk to these people.
Yeah.
My kids don't have checking accounts, and I feel like we've also gotten to the point where, deposits are paid electronically, but then they do need, so what is the word you're using if you're not saying bank check?
Cashier's check.
Just a cashier's check. Okay. So.
And then some will say certified check, but we don't want to go there because a certified check is a real pain.
Oh, okay. So we need a
not for us, but for someone going to a bank to get a certified check.
Yes,
that's just a totally different process for them to get a certified check versus a cashier's check.
Okay,
so cashier's
check. All right, I'm going to make sure I use that word from now on.
Yeah. I'm not going to use bank check anymore.
Yeah. Nope.
So we've had buyers, right at closing, can I have your check? Oh, here's my checkbook. I'll write you this check on my bank for $50,000. Like, no. Can't accept that. Our threshold is roughly $1,000. As far as we'll accept a personal check for.
Right.
I know. I have asked people to bring their checkbook with them in case there's something
adjustment.
Yeah. I know. Actually, that reminds me of one. The homestead.
Yep.
You automatically include that in there, don't you? And isn't it automatic up to 500,000? I've already forgotten. Refresh my memory. I don't go to closings anymore.
So should we talk about what the homestead is?
Please. Yes, please.
So unique to Massachusetts, as far as I know. So we live in a litigious society.
Really?
So if someone. So first off, I tell my buyers, live a good life, live a clean life, don't get sued, but have really good insurance in case you do get sued. But if someone sues you for whatever reason and they get past your insurance, they get a judgment against you personally, now they're coming for your assets.
Right.
You own a house, a lot of equity in the house, they're coming after your house. They're going to try to kick you out of the house, have the sheriff auction off the house to get at your equity.
Yeah.
In Massachusetts, on property that is your primary residence, we have the homestead law in Massachusetts that protects some amount of equity in the home against creditors. So just automatically, whether you know about it or not, every homeowner, property that they own, that they reside in, $125,000 of their equity is exempt from creditor claims. So if someone sues them, they come after the house, equity is less than 125, they can't touch the house.
Okay.
But the homeowner can increase that protection from 125 to 500,000 by filing a document at the Registry of Deeds, having us file at the Registry of Deeds a form called a Declaration of Homestead, and that costs. For us, it costs $38.75 to file that. So it's $35 to the Registry of Deeds, but everything's done electronically now. So
Right.
the e-filing company, we pay $3.75
Yeah.
per.
So now there's a
per
protection
document.
up to 500,000,
So
but
so
without
we
that,
do that
it's-
for every buyer.
I have had people say, should I do it? And to me, it's a no-brainer.
It's a no-brainer.
Absolutely.
Yeah.
Yes. Yeah.
So it used to be that we didn't just presume for people. So we'd have the conversation at closing, and they say, yes, I want to do that. So then they'd write a check for $38.75. But my staff finally convinced me, everyone wants it. Just put it on there so you don't have to go through that aggravation of getting
well,
to
it's
write
not
a
like
check.
you're asking for $500,000. You're asking for $38.75.
And there are attorneys who are going to charge a fee,
Oh, right.
a legal fee for that,
Yeah.
which that galls me.
Yeah.
But because there's no work involved in
Not
that.
at Reynolds Law Office.
Not at Reynolds Law Office, exactly so. We don't. We never nickel and dime our client.
Thank you. I appreciate that. People get nickel and dimed all the time. It's nice if we can avoid that. We don't want your nickels and dimes. We want your dollars.
Exactly.
Awesome.
Well, Craig, I really appreciate
Yes.
that you took time. I know how busy you are, and I feel like we are very lucky that you, came here today on a rainy day and spent some time with us and educated our listeners. And I thank you.
Well, thanks for having me. This was fun.
Yes.
All right. And, thank you for tuning in. Be sure to subscribe so you can be notified whenever we have new episodes released. And if you wish to find Lana or myself, you can find us at Caldwell Banker in Leominster. All right. Take care.